Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Well, after 100 plus minutes of oral arguments, the United States Supreme Court has heard the matter of United States v. Rahimi. It is a case that is questioning the constitutionality of 18 United States Code Section 922G8. That is the statute that says if you're under a domestic violence protection order, you cannot possess a firearm. This case has the potential to have huge implications. It has the potential to have not that big of a deal. Don't believe me? We'll get you educated and we'll go through some predictions because I think we got an idea of where this is going. So today, let's spend a few minutes and let's talk about predicting what happens in the Rahimi case. Okay, so the case we're talking about today is United States v. Rahimi. Everyone's been talking about it for the last 24 hours. Now, because I run a law practice during the day, it's now 7:45 in the evening out here on the West Coast. So we are doing our Rahimi prediction special in the evening on the day of arguments. You will be watching this the day after oral arguments. Now, whenever we're trying to read the tea leaves, if you would, you can look at the briefs, you can look at the amicus briefs, you can look at a lot of things. But if you really, really want to get a flavor, a sense of where the court is likely going, what you really need to pay attention to is the questions that come from the bench to the attorneys. And who are the justices that are asking these questions, okay? So, for example, if you are rooting for Mr. Rahimi in this case, and you have conservative justices asking questions that make you appear as though they may be siding with the United States government, that would not be a positive sign. So, what I had an opportunity to do today is I listened to all 102 minutes of oral arguments on this. I am going to give you some highlights. I'm going to give you some lowlights. And then based upon that, we are going to give you our prediction. Okay, now for starters, we got to first figure out how broad of a ruling do we think this is? Now, we know the issue of do domestic violence protection orders preclude an individual from possessing firearms is absolutely positively going to have to be answered by the court. Washington Gun Law is predicting, however, that the court is really only going to rule on that issue. On a much broader scale, they could rule on a lot of things related to a lot of the procedural concerns that we have expressed, that many of you have expressed when it comes to red flag laws, protection orders, anti-harassment orders, where really there is no sense of procedural due process afforded the respondent to those orders. I don't believe that the Supreme Court is going to weigh into those waters. I believe that we're actually going to get a very narrow ruling. I think that from a page length, it's going to be remarkably short by United States Supreme Court standards. And I think that the Supreme Court, the majority opinion here, is going to stick to the one specific issue, which is it constitutional to remove Second Amendment rights from those that are currently under domestic violence protection orders? Now, there were several observations I made, and they really go kind of hand in hand with what a lot of other people were talking about before the arguments. The first observation that I made is that many people had argued, well, there's no way the court can uphold this law because there was no such thing as domestic violence laws at the time that we ratified our Constitution. And that is actually pretty much true. However, after listening to the court, I can assure you that that is not an issue with any one of the 9 justices. As I have said before on multiple videos, I do not believe that to be an issue either, because the issue is do we have a historical tradition of disarming individuals who we believe to be dangerous? It's not about whether or not they've been convicted or accused of domestic violence. Dangerous comes in many, many forms, as we know, by taking a look at some of the historical analogs that we have examined. What's also clear from the arguments today is that the Bruen opinion is and forever will be under attack by those that favor civilian disarmament. Consider how Solicitor General Elizabeth Prelogar talked about the Bruen ruling. I think that it's important for the court to understand the destabilizing consequences of that reading in the lower courts. Now, understand what she means by the destabilizing consequences is the fact that many courts are going back and taking another constitutional view of pre-existing statutes to ensure that they are still constitutionally compliant. That's the destabilizing effect that she is talking about. What also is clear is that there really is no debating, and there certainly will be no persuading any justice on the Supreme Court that Mr. Rahimi himself does not constitute a dangerous person. Consider this exchange between Mr. Rahimi's attorney and Chief Justice John Roberts. Justice Roberts: well, to the extent that's pertinent, you don't have any doubt that your client's a dangerous person, do you? Mr. Wright: Your Honor, I would want to know what dangerous person means. Justice Roberts: well, it means someone who's not shooting, at people. That's a good start. And that exchange drew laughter from the courtroom, and Mr. Wright, counsel for Mr. Rahimi, did state that that was fair. I don't think that there is any convincing any justice, and candidly, anyone who understands the facts of this case, there really is no convincing that Mr. Rahimi himself does not constitute a dangerous person. That, however, is not really the issue here. The issue here is whether we as a country have a historical analog or historical tradition of disarming people, such as Mr. Rahimi. What's also clear is that liberal justices will continue to challenge the constraints of the historical analog rule requirement and will do anything humanly possible to do away with that analysis. Consider the exchange that Justice Kagan had with counsel for Rahimi. Justice Kagan: is that what we should do? Be looking for, and if we don't find that similar ban, we say the government has no right to do anything? Mr. Wright: Your Honor, I think that's largely what Bruin says. However, I don't think it has to be so narrow. Another observation: if Mr. Rahimi loses, it will make a huge difference whether or not the court deems him to be dangerous or just irresponsible. The United States government clearly wants a new test carved out, which is that any individual that society deems as dangerous or irresponsible can be precluded from exercising their Second Amendment rights. I don't really believe the court was having as much of that, at least not the conservative majority. But it does appear that all 9 justices are willing to adopt some type of dangerousness standard. And there was an exchange between Chief Justice Roberts and counsel for the United States government that kind of demonstrated where I believe the majority of the court is going here. Justice Roberts: just to be clear, your argument today is that the Second Amendment doesn't apply to people who present the threat of dangerousness, whether you want to characterize them as responsible or irresponsible. Whatever the test that you're asking us to adopt turns on dangerousness. Counsel Preligar: correct, for those who are not responsible citizens. I do want to be clear that we think there are different principles that apply with those who are not law-abiding. So I just want to be clear. We don't think dangerousness is necessarily the standard here, although there's obviously going to be a lot of overlap. That's defined by its own history and tradition. But we do think that dangerousness defines the category of those who are not responsible. But when the United States attorney was offering the theory that there is a tradition of disarming individuals based on dangerousness, Justice Coney Barrett agreed and was quoted as saying, the legislature can make judgments to disarm people consistently with the Second Amendment based on dangerousness. Now, why is this important if this is the test that is carved out? Let us remember that there is another case that the United States government has asked for review on next year, which is the matter of Range versus Attorney General of the United States. Now, in that case, Mr. Range is a convicted felon, but there is absolutely no allegation, and there will be no way for the United States government to establish that Mr. Range ever posed a danger to himself or others. Therefore, if the court carves out an exception here or carves out a rule in which individuals that are deemed to be dangerous can have their Second Amendment rights removed, however, those who are merely irresponsible cannot, then Mr. Range and anyone who falls into the category of those plaintiffs stand a very good chance of success before the United States Supreme Court. So, with all of that in mind, what is our predictions? Our predictions is that the United States government will prevail on this. They will get at least 6 votes in favor of upholding 18 USC 922 G8. And Washington Gun Law is predicting that the majority opinion, which will be very narrow in scope and deal only with this one limited issue, will be authored by Justice Amy Coney Barrett. It is really important that the court issues an incredibly narrow decision because there will be many on the civilian disarmament side who will say that this is a complete paring back a taking back of many of the advancements of rights that occurred under Bruin. That is not the case, but we have already seen the Heller example, and we've seen the Bruin example, where if you just drop a couple of extra little words in there in dicta, suddenly in common use becomes in common use for self-defense. And we know how if you give them even a quarter of an inch, they will try to take a mile. Here's another prediction that you can bet on, is that when this opinion is published, the mainstream media and those who favor civilian disarmament will just absolutely scream from the top of the mountains that this was a huge, huge victory and an advancement for reasonable gun control measures. The bottom line is that if the United States government wins, what it means is that the law remains status quo. Nothing changes. But also remember that when they are screaming from the top of their lungs what a glorious victory this is for the advancement of civilian disarmament, they will also be criticizing this court as a renegade, activist, right-wing court. The ruling should be out sometime late June, early July. Obviously, if there are any more developments, we will let you know. Highly unlikely now that it is in the hands of the United States Supreme Court. The case, once again, is United States v. Rahimi. We'll link up all the audio down below, so if you're really bored and you want to geek out on it for yourself, go ahead and do that. In the meantime, if you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also down there in the description box. Now, in the meantime, let's remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.